this is again lecture 3. We're going to continue with alternative dispute resolution, and what I decided to do is give you 2 cases that we're going to discuss to show you how the court is very controversial about these things, because sometimes when you bring a case in a court of law, for example, like Gilmer in 1991, age discrimination cases, it's very interesting because he knows that in a court of law, he would have better chances to win than in arbitration. Why? Because in a court of law, we have such a term as a prima facie case, and that means on the face, the case can be heard in court. So here is this guy that is over 40 years old, age discrimination in the United States. If you're over 40 years old, you're protected by the law, because it could be that you are not hired or you are terminated because you're over 40 years old. And so, and if you're terminated and you're over 40 years old and they hire somebody 38, 39, under 40, that's what we call a prima facie case. You have the case to be heard in a court of law, and there's 51% chances that you will win the cases, even if the corporation has 49% that is not necessarily true why they terminate you. So Gilmer goes to court because he is age discrimination, and he believes that he was discriminated because of the age. And of course, when he went to work with this company, he had a contract that had signed that if there was any controversy or any dispute, they were going to go to arbitration. And you can see he was in a stock exchange. It was something to do that it was pretty regulated by the government. And the Gilbert decision was and remains controversial, because in that case the court says that he has to go to arbitration. Because being that he's an adult in the contract, he had to go to arbitration first. Now, if then he was not pleased with the opinion of the arbitrator, and he thought that the opinion was arbitrary and biased, then the court will review the opinion, and then they will decide if they should go to court or not. But in this decision, the court decided that he has to go to arbitration first and not to court first. And here is a nice chart to just show you the example between negotiation, mediation, and arbitration, so that you will have your time to read it if you want to even print it out, and it's very, very interesting. What makes the final decision? In the negotiation, the party, there's no question. They have to decide it. I agree with what the judge is suggesting, so we don't go into court. The mediation, again, is the parties that make the decision. And in arbitration, instead, binding arbitration is the arbitrator that makes the decision, just like a judge makes a decision. And the only thing is, if his decision is biased or, again, arbitrary, then the court will read the opinion. Are the facts found and standard judgment said? Parties decide the last moment. Party decides, arbitrator decides based on the present rules and those of the American Association. It was very interesting, and you'll see that they have set up rules, but the arbitrators makes the decision. Where the other two, the negotiation and mediation, the party decides. So we're going to discuss this more on our board of discussion. Thank you.